Welcome, everybody, to the latest installment of the Insurance Law Workshop. I'm very happy to introduce you to Meirav Furth-Matzkin, who's joining us from Tel Aviv, where it's very late, and so thank you to her for staying up for this. She's an associate professor of law at Tel Aviv University Law School and will be sharing her paper, Contracting for Deference, with us today. So over to you.
Great. Thank you so much for having me. I'm really happy to be here. And as I told Travis and Peter, this is the first real insurance law forum that I'm presenting at. So really looking forward to your feedback and to talk about an ongoing project titled Contracting for Deference, Discretionary Clauses in Insurance Contracts, and the Problem of Differential Judicial Review. And as the title of this project suggests, it investigates the use of discretionary clauses of the type that give insurers unilateral discretionary authority to accept or deny claims or to interpret terms in contracts, which may trigger a narrow judicial review standard and may have significant implications for consumers. Um, just to give you a little bit of background, each year insurers process billions of health, life, and disability claims, and between 10 and 53% of those claims, depending on policy type, get denied, amounting to an estimated $130 billion each year, and that's a conservative estimate. And the stakes for consumers, for policyholders, of course, cannot be overstated. These decisions often involve life and death situations and significant dollar amounts. So think about the patient who desperately needs a bone marrow transplant or the cancer patient that seeks reimbursement for a chemotherapy treatment. And denial decisions might leave consumers without necessary care or with a huge debt. So, unsurprisingly, claim denials have been a source of public frustration and mistrust. And you may recall that this issue made headlines recently around the murder of the United Health CEO in December 2024, where public media users or social media users blamed insurance companies of killing for profit by arbitrarily denying claims, by abusing their discretion. And now, of course, policyholders whose claim gets denied are entitled to appeal that denial in court. And with respect to employer-sponsored plans, they can appeal the denial in federal court. However, the scope of judicial review varies by context. And in the context of employer-sponsored plans, it depends on the presence or absence of a discretionary clause. So specifically, when a discretionary clause is included in a plan, it may shift the standard of judicial review from de novo, which means that policyholders would have the opportunity to present the case anew, to the differential, arbitrary, and capricious standard, which means that courts would only intervene if they deem the decision excessively unreasonable or arbitrary. And this shift was made possible due to a US Supreme Court decision from 1989 in a case called Firestone v. Brooke, where the Supreme Court settled this long-held debate between lower courts about the proper standard of review and determined that the proper standard would be de novo. However, the court at the same time also noted that the parties could contract around the de novo standard by including discretionary language. So basically creating this carve out and making the de novo a default. And the decision that allowed or was seen as an invitation to contract for deference was reinforced by following Supreme Court decisions, including Metropolitan v. Glenn in 2008 and Conkright v. Frommert in 2010. And it also prompted concerns among scholars and commentators that insurance companies would use this invitation to insert discretionary language and get this shield from meaningful judicial review that they would then also use to more aggressively deny claims. So, as a result, 25 states have gradually adopted bans on discretionary clauses following the Model 42 Act by the National Association of Insurance Commissioners in 2002. But due to federal preemption, which I'll soon discuss in more depth, they only apply to insured plans and not to self-funded employer-sponsored plans. So there's a patchwork of laws, and the law was so convoluted that it led Congress in 2022 and 2024 to consider a federal ban on discretionary clauses, but currently the proposals are stalling in committee. So this normative debate has been going on for around 40 years now, notably absent any empirical data. And against this backdrop, important questions remain, right? How prevalent are discretionary clauses in insurance contracts? What do they look like? In which types of plans do they even appear? Have state bans been effective in curbing their use? And of course, what is their on the ground effect? So, to the extent that they are included in these contracts, how do they affect policyholders' access to legal representation, lawyers' behavior and decision, or litigation outcomes? So, this paper tries to take a first step at addressing these questions using a mixed methods empirical approach, including an observational study of more than 1,100 insurance contracts and summary plan descriptions, a large-scale consumer survey, and interviews and an experiment with lawyers practicing in the field. So just maybe tell me if this is like obvious for an insurance law crowd, for an insurance law audience. But I wanted to just briefly explain the legal framework. Can I move on? Okay, perfect. So beginning with study one, it consisted of a wide-scale analysis of more than 1,100 insurance contracts filed in litigation cases that were filed between 2019 and 2022. But the policies that were attached to this litigation file were issued in between 1965 and 2022. So a long time span. Now, of course, let me say in brackets, let me know the limitation of the data set. Of course, this is not a random sample. It's a litigation-based sample, and I used it because there was no publicly available data set. And insurance companies do not always want to share their policies with researchers. But because this is a litigation sample, of course, the question about the representativeness of the sample arises, whether it accurately represents the full universe of insurance contracts. And of course, we know that some denial disputes would never reach court if the contracts that are selected into litigation are systematically different than those that do not end in litigation. For example, if they contain higher discretionary clauses, because we think that insurance companies that litigate would put them there, for example, then we might see a bias, maybe an overestimation of the prevalence of discretionary clauses. And because I was worried about selection, I also compiled a separate, smaller data set, which was obtained directly from policyholders. And I report everything in the paper. And basically, if anything, there's a slight underestimation of this equivalence. So the analysis in the paper, if anything, it seems to be a conservative estimate of the prevalence of discretionary clauses. Happy to talk more in the Q&A. Okay, so in terms of methodology, all contracts were OCR'd and hand-coded by a team of qualified research assistants, and they basically relied on the case law to identify and classify clauses as discretionary clauses because some of them do not specifically use the term discretion or discretionary authority. But courts over time set out like rules or standards regarding the proper language that would trigger Firestone deference. So they basically followed that case law and coded terms that allowed insurers authority to make benefit determinations, deny or accept claims, or interpret the terms as discretionary clauses. Now, coders also classify the contracts along multiple other dimensions, including the governing jurisdiction, the year of adoption, the presence of other types of discretion granting terms or choice of law or forum clauses that I will talk about later. Um, okay, so just in a nutshell, let me tell you what we found. So first, we found that discretionary clauses are significantly more widespread in employer-sponsored plans compared to individual insurance. They appeared in 58% of the sampled employer-sponsored plans and in less than 1% of the individual insurance plans. Again, that is expected in view of the differences in the legal framework. Of course, only when included in employer-sponsored plans would discretionary clauses trigger the deferential judicial review. I did had competing predictions as to whether we should expect to see them in individual insurance plans as well, because we might think about a spillover effect, but in fact, they were not included. They were virtually absent from individual insurance plans. And within employer-sponsored plans, we see an increase over time and a very big spike after Firestone. And you can see it here in this graph. So you could see the dashed red line represents the individual insurance sample. The blue line represents the employer-sponsored plans. And you can see that while the red line remains quite flat over time, the blue line spikes immediately following, in the years immediately following the Supreme Court decision in Firestone. It peaks at 90% in the 1992-1995 year period. Then it gradually declines, and specifically around the time that the National Association of Insurance Commissioners adopts the Prohibition on Discretionary Clauses Act, and then states also gradually adopt the bans on discretionary clauses, but it seems kind of stable around 60%. Okay, so in terms of what these clauses look like, the vast majority of discretionary clauses are comprehensive in the sense that they cover both discretion to make eligibility determinations and interpret the contract. So let me give you a sense of the language that is used. So these are taken from the sample. These were coded as discretionary clauses. And you can see that at least the two here in the center and to the right explicitly mention, right, that they have discretion both to determine eligibility for benefits and construe and interpret terms and provisions in the contract. I will also say 95% explicitly included the word discretion. So there were just very few discretionary clauses that did not use the specific terms.
Can I just
And
ask a can I just ask a quick
yes,
question about that? Go
sure.
back to the last slide. The first block has, seems like much stronger language, and I'm just wondering if there's any sense like, well, why didn't these other guys use that? Like, we can do absolutely anything we want. And if I were writing this, wouldn't you just claim the sun, the moon, and the stars? And it's almost like negligence not to, oh, we have discretion, but we're not going to say how big it is. I'm just maybe this is a technical niggling point, but like, why don't they all say what the first one says? Or is there really no difference?
No, that's a great question, and I'm not sure I have a good answer. I know that, like, I interviewed some of the lawyers who are responsible for drafting these contracts, the compliance counsel who are also responsible to make sure that the contracts comply with the RISA regulation. And some of them mentioned that Judge Easterbrook made like explicit guidelines, so basically dictated the language that should be used to trigger Firestone deference. And some of them just follow that language, but we did see some variation. So yeah, I guess there's now a growing line of research on contractual evolution and innovation in contracts and about the stickiness of contract terms. And while this is true in a sense, they all look alike and many of them use the same terms. There's still a I think a substantial degree of variation. So yeah, thank you for that. Um, Okay, so we also saw that discretionary clauses persisted even in states that have banned their use. So even in the 25 jurisdictions that already impose prohibitions on using discretionary clauses, but at lower rates, especially when we looked at the insured plans that are governed by state laws, because as you may recall, self-funded plans are not covered due to preemption. Um, the policies rarely mention policyholders' right to appeal, so around 20% did mention the right to appeal, but when they did, they often also explained that right of appeal is now subject to an arbitrary and capricious standard. And they explained that this means that that the decision has to be excessively unreasonable or arbitrary for the courts to intervene. So seemingly, maybe to discourage policyholders from exercising that right. And I also want to note a strong positive correlation between discretionary clauses and both types of clauses. So both clauses that limit policyholders' access to courts, like mandatory arbitration provisions, and other types of discretion granting terms, like unilateral change clauses that allow insurance companies to modify the contract without the policyholder's consent, or medical necessity clauses. These are clauses that allow or grant discretion to deter to the insurer to determine what constitutes a medically necessary treatment. So these clauses often appear together. I think highlighting the need for researchers to study their cumulative effect and to think about these not in isolation, but about like the collective effect of these terms on litigation outcomes. Okay. So study one reveals two key patterns, right? One is we see that discretionary clauses are widely used in employer-sponsored plans post-Firestone. And two, we see that they remain largely absent in individual plans. As I mentioned, I think the most immediate explanation is that Firestone deference only applies to employer-sponsored plans that are governed by ERISA. But there are also other structural differences. And when I started presenting this, people said, well, there are also differences in the bargaining dynamics, in the parties to the transaction, in regulatory oversight that could explain the disparity. So what I did was I also collected a sample of summary plan descriptions. These are the simplified forms that summarize the most important terms of the policies. And I looked at summary plan descriptions of both private and public universities because private universities are subject to ERISA and therefore can use discretionary clauses to trigger Firestone deference, whereas public universities are exempt because they are considered governmental entities and they cannot obtain Firestone deference. And I follow the same coding process as before. And again, the hypothesis were, well, when we have no bans on discretionary clauses, we surely should expect to see higher rates of discretionary clauses in the private institutions that might benefit from triggering Firestone deference. In the states that have bans, I also expected to see higher rates of discretionary clauses in the self-funded plans compared to insured plans, both in public and private universities, SPDs. And consistent with these predictions, we did see that private institutions, SPDs, had higher rates of discretionary clauses, but public institutions also had relatively high rates of discretionary clauses. So this is kind of puzzling. I can happy to discuss some potential explanations. And in jurisdictions with bans on discretionary clauses, we did find that self-funded plans had higher rates of discretionary clauses, but we still saw, as you can see here in this figure, that even insured plans have significant rates of discretionary clauses. More than a third of the insured plans had them. And these are, again, unenforceable because state laws do apply. So potential explanation for why we're seeing these unenforceable terms, it could be inertia, contractual stickiness, for firms use the same templates across different types of contracts, could be ignorance about the law or hope that the law will change or hope that the clauses will affect courts even if the formal law does not dictate deference, or maybe a less benevolent story is that firms think that these clauses can discourage claimants from taking them to court. And again, I'm happy to discuss some other literature, including some of my prior work that is consistent with these different explanations. Okay, so moving to study two, and I see that I'm almost out of time. So study two consisted of a survey of policyholders, and mainly I was interested in understanding whether they even read their insurance policies, and to the extent that they do, what they understand from reading a discretionary clause. Here you can see in the figures their responses to two main questions that I asked. One is, in what situations do you typically read your health insurance documents? And as you can see, while a significant proportion, 38%, said they did read prior to enrolling in the plan, as many as 55% said they only read post signing. So when a problem arises, for example, when their claim gets denied. And the second figure to the right, you can see the responses to the question, how do you think a discretionary clause would influence the way courts review your case? And I thought it was interesting to see that most of them understood, or at least intuited, that the courts would give more deference to the insurance company based on this language. This was like a close-ended question with three types of responses, but I also asked them before I asked that question. I asked an open-ended question where they could answer freely, and then we coded the responses, and we saw that most understood what these clauses meant. But of course, if a claim gets denied, policyholders might also consult an attorney. So I was also interested in understanding how attorneys reacted to those provisions and how those provisions affected litigation dynamics, and settlement decisions. Okay, so for that purpose, I did two things. I interviewed lawyers, and I then also ran a randomized experiment on legal practitioners. So with respect to the interviews, I interviewed 18 insurance professionals, both defense and plaintiff's attorneys, and also compliance counsel. I used the snowball approach. Happy to talk more about the method later. In terms of the findings, I saw that interviewees believe that discretionary clauses are widespread, both from the plaintiff side and the defense side. They thought that they were highly widespread, especially in employer-sponsored plans, especially with larger employers that use self-funded plans. They thought it could be even malpractice not to include these clauses. And some did mention that they would include discretionary clauses even if they're unenforceable, to discourage policyholders from challenging denials in court. And I put the quotations, the sites in the paper. You can look. It's really interesting to see. And in terms of how these clauses affected litigation, it seems like, again, for both sides, the lawyers believe the discretionary clauses and the associated differential standard of review are highly outcome determinative, means that they do affect, they have a huge effect on how courts would review these cases, especially in what they term the close call or gray area cases, as opposed to these like clear cut cases. And plaintiff side attorneys reported as a result that they would be reluctant to take on cases, even strong ones that they would take in a minute under de novo review, if they anticipated that the case would be litigated under an arbitrary and capricious standard. Defense side attorneys at the same time reported that they would be less willing to recommend their clients to offer high settlement amounts under an arbitrary and capricious standard as opposed to de novo. So it seems like from both defense side and plaintiff side attorneys are deeply affected by the presence or absence of a discretionary clause, and that they believe that courts also are affected by the governing standard of review when making their decisions. Okay, but I then also tried to see if I could tease that causal effect, at least the perceived effect of the standard of review on litigation outcomes using a randomized controlled experiment. And for that purpose, I sent three of my RAs to a lawyers conference, an ERISA lawyers conference in Denver, Colorado, in April last year. And they managed to recruit 79 lawyers to fill out a short survey. And in that survey, they read a short vignette. The scenario described a real case, Brigham versus Sun Life, in which a policyholder who became a paraplegic filed a claim for long-term disability benefits. In that case, he was denied the benefits. But of course, I didn't tell them that. I just told them the facts in brief. And they were asked to predict first how likely it was that the claims administrator would approve or deny the claim, how likely it was that the claimant would appeal a denial, and how likely it was that he would win on appeal. And without their knowledge, they were randomly assigned to either a de novo standard of review condition, an arbitrary and capricious standard of review condition, or a no information condition, which they were not provided with information about the applicable standard of review. So let me just briefly show you the results and then we'll open it for Q&A. So here you can see the lawyer's predictions by experimental condition, where the blue bars represent the no information group, the red bars represent the arbitrary and capricious standard group, and the green bars represent the de novo group. And to the left, you can see the response to or their prediction about whether the claims administrator will approve the claim. You can see that they were quite pessimistic about the chances that this claim would get approved. There were differences between the de novo and the other conditions. These are not statistically significant. I'm suspecting because of a floor effect. Basically, they all thought that like there are very low chances that this would get approved. But at the same time, they did anticipate that the policyholder would file an appeal. And here we could see already a large difference between the de novo and the arbitrary and capricious group in terms of the chances that the policyholder would file an appeal, with lawyers thinking that the policyholder would be more likely to file an appeal under de novo. But I think the main finding here is the striking difference between participants in de novo versus arbitrary and capricious in terms of their predictions of success on appeal. And here we could see that participants were highly influenced by the experimental condition, right? So 9% thought that the insured is more likely than not to win under an arbitrary and capricious standard, compared to as many as 70% under the de novo condition. So basically, the standard of review managed in this case to turn a complete loser into a complete winner in court. Okay, we can talk about the limitations of this study and about future directions. I also have normative. I already have some normative sections in the paper. As an empiricist, I'm always hesitant to include them, but I feel like after having studied this extensively, um, I do have a standing, and we can talk about it if you like in the Q&A. So I'll stop here. I'm really looking forward to the discussion.
Great, thank you. So the floor is open for questions, and I'll keep the queue. So Walter Welsh with the first question. You're muted, Walter.
See,
I
can you hear
think
me
he
okay now?
Yep.
Yeah, I'm probably the
Great.
slowest on the microphone, Professor. So, first of all, thank you for doing this. I teach one course in this our master's program at UConn, which has life insurance, annuities, disability income, and long-term care, and ERISA. We throw it all in 14 weeks, so you got to get all of it.
Wow.
And part of that is, of course, this Firestone case and what happened after it. And some of the students who want to know about insurance, but if I teach them that they have to know a little bit about tax, they just wave their arms and don't want to know that. And then I add ERISA to the mix. But it's a good way to learn a little bit about all the fair parts of law that affect insurance contracts. I wanted to mention one thing. When I went through this one, I used to work for an insurance company, and California said we could not have a discretionary clause in the disability income policy that we're filing with the state for approval. So they stopped them. But the companies took the discretion into the plan. And so the insurance policy did not have any discretionary clause, but the uh, the employee benefits plan had the discretionary clause sitting there so that you could still operate under ERISA, not by having the insurance company make the decision, but by the plan administrator. So it's an interesting way around this. You would say, now the problem is sometimes the insurance company would slip back and be the administrator as well, even though it wasn't in the policy. So that's something to think. I don't know if you've seen that. Have you seen that at all?
So can you again explain what you saw? So you saw that they took it out of the policy and then put it in the
Into
in
the
the
into the plan where you made a claim for disability benefits, and the discretion was in the hands of the trustee, who was a plan trustee, not necessarily the insurance company.
so the administrator.
Yeah, and
Yeah,
so
I did see that.
yeah, so
Yeah, I did.
it's a change. So it was just a change. I mean, this is interesting. I have to have my students go back and look at the Firestone case, and Justice O'Connor wrote, and so much of what she writes is looking at the trustee of a plan being different. They owe a duty to the plan beneficiaries. They have fiduciary duties. So she's willing to give that trustee discretionary authority because of that other duties. And you can argue whether those are real duties or not, but there is a fiduciary duty on the trustee. So I think that's how she ended up in that decision where she did, and what you're looking at now. So that was two things I wanted to bring up. One was that there is this other sort of cloak of trusteeship ERISA law sitting on top of the trustee and how they exercise that discretion. The other thing I think is you mentioned in the article, and you didn't mention it today, there's some moral hazard on the employers if they choose an insurance company that has a discretionary clause. And what I think about is the employers don't have to provide disability insurance. And given the pressures they're under today, because health insurance has become a much bigger part of if they provide it, that they are looking for the most cost-effective way to do it. So they either are going to have the policy that's offered by the insurance company or no disability coverage. And you're right in your paper, you noted that's harder for the plaintiff who might want to have a large claim. But just to think about how the employer is looking at this, I want to provide in disability income insurance for my employees, but I want to do it at the least expensive cost. And if I can't do that, then I'm not going to provide it at all.
Great. So thank you for all of these comments. So let me address them in the order you asked them. So I think you're right that Justice O'Connor uses the trust law paradigm and relies a lot on the fiduciary duties of the trustee. And I'm not a trust law or a fiduciary law scholar.
And neither am I,
I
and
am a
neither am
corporate
I.
law, but I no, but my intuition is and that we touched on it a little bit with the moral hazard, is that when the trustee is in a structural conflict of interest, I'm not sure that paradigm fits very well. And note that I think that the insurance company is in a conflict of interest, both if it's an insured plan, which means that the insurance company pays out of pocket, but also when it's a self-funded plan and the insurance company administers the plan, but is hired by the employer who then pays out of pocket. So I'm not sure that trust law here works effectively, and maybe it's not. Again, it's not coincidental that I think that the contract law paradigm is more suitable. In terms of moral hazard, and I touch on it and I elaborate on the paper. Yes, so you could think, well, okay, so they have the discretionary clause, but if it's an employer-sponsored plan, we have the employer, and the employer can monitor the insurance company. The employer has the employee's interests at heart, right? That the employers want to keep the employees satisfied. So there's like a private ordering story here that could be told, but here I'm concerned because of that moral hazard problem where employers seem to be focused, and there's empirical evidence on that as well. They're focused on the costs, and they're focused on driving down costs, partially also because that's what employees care about, right? So employees also care about keeping their
Absolutely.
prices
It used
low.
to be all employer paid, but today it is uh, the employee has to pay at least part of it.
Right. So what I'm concerned about is, okay, it may be the case that if discretionary clauses are included, the prices are lower. It even makes sense. But then at what cost? And who then ensures that insurance companies do not excessively deny claims if there's no really meaningful judicial oversight? So that's where I worry.
I
On
think
a
it's a
place.
I think that's it's a well-made point in your paper as well, is that the from the employer's perspective, they just want to cover as many people as they can. And they're not really worried about the actual event of disability as much as having coverage for all their employees. And the insurance companies providing insurance really want to say you should at least do this. Besides health, you should do. Same thing happens with group life. It's interesting to look at this. One of the advantages of teaching the course we have in the at the UConn program, I sometimes will get a lawyer who works for the insurance company and one who's a plaintiff's attorney in the class. And then I would just let them fight about whether the claims denial was good or bad. It's amazing. So the ones who work for the insurance companies are like the policemen who've seen too many people run red lights. They just think all claims must be not both. So we let them just go. It's a good way of looking at this. But I think your paper is really good, and it's a chance for me to let my students take a look at this as well when we get to the course next fall.
Thank you so much.
Great. So we have Esserhan and then Dan Schwartz, and I'm going to put myself on the queue after that.
Hi, do you hear me?
Yep.
Yeah.
This is an amazing paper, especially for the methodology. I think that legal scholarship needs these type of papers a lot more than just data papers or interview papers, but papers like that give us a combined full picture of the situation. I was going to give a full praise of this paper at first, but it didn't happen, sadly. But I think
You
there's
will
a
never forgive me for that.
no, no. I want to tell them I prepared for this paper in the past, so that's not. I I was more prepared than maybe the workshop people. So I think there's one unresolved issue, and it is about the employer's position in this market. So this is what I am thinking. I mean, employers, you frame this as a consumer against insurance company framework, and consumers are naive, insurance companies are sophisticated. But when employers get into the factor, they are sophisticated also, and they are repeat players. And my contract is with the employer, and if insurance company screws me over, I am angry at my employer, not the insurance company. So I think employers' role should be explored. So you cite price sensitivity, and if I don't know if that's true, but if that's true, then the prescriptions differ because if employers are trading differential review for lower premiums, that is more like a rational principal agent problem, not a fine print explosion. So then you should then if then if you go with your prescription and then discretionary clauses, then they will probably push cost reduction to other margins, like more narrower networks or stricter necessity definitions. So I think employers' role, I mean, maybe it's gonna make your paper too long, but maybe a part 6 where the employers play, what type of role, or like do larger companies like how Walmart's discretionary clauses are different from a boutique company, and maybe in the same market, maybe Walmart doesn't allow discretionary clauses in the insurance contract, but like for a small boutique company, they don't have kind of leverage. So insurance company is putting there. I I think that part also needs to be explored for the full picture.
Great. So thank you so much. And again, apologies for missing sales. I had COVID. Anyways, valid point. I have tried in this version. I don't know. Have you read this version of the paper yet? Because it is significantly revamped.
Oh,
And
I just
and,
read
and,
the
and and thanks to
entry.
your comment, because I think you already made that suggestion, not in sales, but in another, right? I think in Chicago.
Yes.
Anyways, so based on your suggestion, I did further explore the role of the employer, but I must admit that I'm still, okay, I acknowledge that employers can play a role in disciplining insurers and preventing some bad faith, egregious behavior. Again, I'm still concerned because I feel like the employers' incentives are not perfectly aligned with employees' incentives. And one reason is again that employees do not understand the true ramifications of discretionary clauses. A, because they may not notice them, but even if they do, because of a bunch of behavioral phenomena like optimism bias and present bias, they might underestimate the likelihood that they will get sick or disabled and underappreciate the role of discretionary clauses in claim denial decisions, or even underestimate the chances that they would get their claim denied. So I'm concerned about the moral hazard problem here with respect to the employer. Now, employers do have fiduciary duties, and Amy Mohannan and Barack Richmond have this amazing. They have just conducted and published this amazing survey, and in some, and there are now cases pending. In which employers have been held to breach their fiduciary duties, but this is in terms of like not making sure that the prices are low or sufficiently low or competitive enough, not because they failed to negotiate having the discretionary clause removed. So I think we're not there yet. And I would also mention switching costs. So employers are also restricted in terms of how likely they are to switch an insurance provider. I know everyone has this example in mind where, NYU just switched the insurance provider, but these are like these are highly disruptive and costly transitions. So in terms of switching costs, there's also a problem here, and that can affect how effectively employers can monitor the insurance providers.
Great. So Dan Schwartz, and then me, and then Peter Siegelman.
You. Um, it's great to hear this project. I talked to you about it, I guess, a while ago. So just a few sort of assorted points. Um, the first point is, I think, just a smaller one. You mentioned that there were other contract provisions that might work in parallel, like discretion to decide medical necessity, and also um, the capacity to unilaterally change terms. And I would just say I'm a little skeptical that those have independent meanings, particularly the one about discretion of deciding medical necessity. I think once you have discretionary clause, the meaning of that is that you have discretion to decide medical necessity. Even with the sort of capacity to unilaterally change, to some extent, as long as you are talking about changes in the medical necessity criteria, I think that would largely overlap. So just a thought that I'm not sure how much those correlations are going to matter. And I wonder if it might be possible to come up with or to evaluate whether there are other terms that correlate with these. One thing that might be interesting to look at is if you have the names of these employers, to look at whether or not like average salary of employee correlates with using a discretionary clause. Like one, naive hypothesis might be that higher income employers are more likely or less likely to use discretionary clauses. And so I think that might be something could be a test based on your data. Second, you obviously mentioned and are aware of the fact that there are limitations to the data set. And like, I think it's great that you're doing sort of notwithstanding that, like, I think good. But I just want to highlight there are some particularly challenging elements of looking at litigation here, because it's not just discretionary clauses. It's like the whole suite of things that make it really difficult to litigate ERISA claims. And the biggest one really is probably not even discretionary clauses, but the limited remedies that are available.
Yeah, that's
And
super
what that
compensatory.
means is you're only going to get like a very small slice of potential claims. And so I just wonder whether there are, other ways besides litigation to try to get at these. You mentioned maybe like crowdsourcing them, and I'd be interested. Like employees can get access to their insurance policies, and so I just wonder whether that be third. Again, these are mostly to serve miscellaneous points. You mentioned that, like, I forget what it was, 35 or 40% of people claim to have read their insurance policy. We did a similar thing in the paper I have with Kyle and Brenda and Herman, looking at sort of can people understand their insurance policies, and sort of found systematically no. But what we also found is lots of people said they read their insurance policies, but then when we dug down, they actually didn't understand what that meant. And they thought that because they'd read like their deck page, they'd read their insurance policy. I wonder whether you're getting the same thing here. They've read the summary of benefits, they've read the website. I would be shocked if anything close to the percentage you mentioned have read their insurance policy. Final point, and this is sort of the more like the normative takeaway point. Um, I agree that actually one thing to really look at is whether or not like employers play a role in sort of navigating these claims in a way that maybe makes discretionary clauses a bit more justifiable. But one thing I would say beside that sort of amplifies your response there, besides the agency points, is the fact that you would also imagine that it's going to systematically differ depending on the income level of the employees. So for instance, like University of Minnesota, actually, it's pretty good. If people have problems with their insurance claims, they often come to me, and I'm able to work through the University of Minnesota through it to like get the issue resolved some of the time because they like listen to me. Like that doesn't happen at every employer. So and it's systematic about which employers are more likely to do that, which aren't. So if you care about sort of the distributional consequences, then you should care. The other thing, though, on the flip side, that I actually think is super important is looking at the question of external review. Because one thing that is distinctive, at least about the health insurance side, is the fact that there's a right to external review, and discretionary clauses don't apply to external review. External reviewers apply a de novo standard of review on medical necessity, and at least in theory, and maybe that's a perfectly adequate and good way of resolving these contested claims. And we have experts who are doctors at least for health insurance. And I think I don't know actually how prevalent external review is for disability or for other forms of insurance, but I think that's a really important piece of the entire normative puzzle. Final point, again, I sort of apologize for this list of just random things. I wasn't so sure about the law on public universities and whether or not, even though they're not subject to ERISA, whether or not it's super clear in every state that discretionary clauses wouldn't be enforceable. Because that was the most surprising finding you had. And I just was wondering if you could dig into that a little bit more. You don't necessarily have to do it here, but I just wonder whether it's a bit more complicated with public universities, whether or not there might be some nuances in whether a discretionary clause might be enforceable, even though ordinary insurance policies wouldn't be. So those are my thoughts.
Yeah, thank you so much. There's a lot here, and I'm mindful of the time. So um, I think I'll just take more questions. But the points are well taken, and especially the last one. When I prepared for this presentation, I also thought maybe one of the reasons why I'm seeing discretionary clauses in the public universities SPDs is that the law isn't super clear, or lawyers who draft these SPDs are not super clear about whether the Firestone deference rule applies.
Um,
I
Great.
see
So
here.
um, I'm gonna go next, but before I do, I'm just gonna say that I'm going to paste in the chat a link for those who are interested in getting CLE credit in Connecticut for this. Um, and if you would like CLE credit in another state, there will be a link for you to indicate that. We're just rolling it out state by state. So, okay, great. So thank you, Mira. Again, super interesting paper. Two thoughts or points. So one, not to ask you to make an already very long paper or like whatever, rich paper even richer, but my understanding is that phenomenologically,
I can always write another paper. That's
great,
okay.
great. But so my understanding is that phenomenologically, like the way this sort of economy works is that one of the key players involved is the broker or benefits advisor. And that those, like the Aon or Lockton or Mercer, like those companies are the ones that put together the SPDs and have like standardized sort of wrap documents on, and that may be a key sort of bottleneck that produces certain types of standardization that you're seeing here. And so just like as a sort of mechanism, it may be worth looking into that. I know that like, the like the Aons of the world, like they have their own internal lawyers, but the people who are working with the employers and stuff are themselves not lawyers. They're broke. And so like just as a piece of the sort of machine, that may be another part worth studying. And my sense is that it's like relatively easy to study in the sense that there's like, a relatively few players comprise a very large segment of that market, especially for larger employers. Um, Second point, and this is something that just occurred to me while you were talking, is that it seems to me there's a kind of funny paradox here, which is that like if you look at normal insurance policies like homeowners insurance or uh, um, auto insurance or something, like those policies are incomprehensible even to many of us. And yet they're subject to the contra preferentum rule, which one would think would create an incentive to make them as legible as possible. By comparison, SPDs, which are in many cases the closest one can find to a health insurance policy, like to a description of the health insurance benefits that you get, are far more legible. And I'm just stating that, but I've read a bunch of both different kinds of, documents, and I find them to be like pretty readable. And yet they're not subject to the contra preferentum rule, and so there's a sort of paradox here. Like, is there a thing where, like, if the entity writing the policy or something like the policy isn't subject to contra preferentum, they're able to kind of go out on a limb a little bit farther and use language that's like more plain spoken, and which would make a lawyer nervous. But if there's no downside risk to it, then they can take a chance and just try to speak a little bit more plainly. And so anyway, that maybe that's crazy, but it seems like an interesting paradoxical result of the dynamic you're describing here.
Great. I haven't thought about that paradox point. I think in terms of contra preferentum, what I was kind of surprised to see was how easy it was to contract around that principle. And when I started this project, I actually I talked about it with Dan and with others who were working on contra preferentum, and at least some of them, like Tom Baker from Penn, who was one of the reporters of the restatement of liability insurance, had the impression that no one really contracts around contra preferentum, and that contra preferentum should be a mandatory rule, at least in the context of insurance contracts. And then I found these discretionary provisions that grant insurers discretionary authority to interpret terms. And what I was now even more astounded to find was that courts interpret these as contracting around contra preferendum. So basically, under the arbitrary and capricious standard, courts refuse to apply contra preferendum even when there is ambiguity because of that language. So but that's the point about the paradox point is really interesting. Thank you.
Peter, we have time for one more question if you want to go.
Well, yeah, I'll try to make it quick. So, you talked a lot about moral hazard, but I didn't see that much in the paper about adverse selection. And one of the interesting things, there's great research by Nathaniel Hendren about what sort of motivates adverse selection in health insurance markets. And his point is, what you really know about yourself that your insurer doesn't know about you is not your health status. It's your kind of willingness or desire to push for a lot of treatment. Like some people get confronted with a serious problem and they go, I'm just going to give up. And other people say, no, even though it's a fatal disease, I want you to spend every last, penny you can on high-end treatments that probably won't work, but that's what I want. And so if that's the world that we live in, it seems like, all right, maybe there's a different role for these discretionary clauses. Like the insurer needs to be able to keep control of who's going to get what, because that's exactly the margin on which selection is most operative, and that can lead to just the collapse of the whole thing. So I don't know if you have any thoughts about that, but that was my question. I also have some other
Yeah.
comments I'll
So
send you later.
no, that's great. And so the short answer is it's okay to have discretion. I just don't think that it necessarily should trigger a highly differential standard of judicial review. So it's one thing to have the discretion and then use that discretion to screen out like the bad apples who try to, either abuse the system or in your example, just try to push for treatments that might be too costly and experimental to be effective, or to be cost beneficial. And it's another thing to use that language to trigger a differential review where courts are almost like a rubber stamp. Um, I refer to this ChatGPT made image here of letting the fox guard the hen house. Um, so that's the short part. The long part is I was interested in that actually, and you're right that I haven't done it in this paper, but I have another paper in Northwestern Law Review about discrimination, what I call discrimination in contractual performance, and this is this idea that firms can use discretion, whether or not it's explicit in the contract, to segment between consumers. And the argument you made is kind of consistent with arguments that others have made in the past, like Babchuk and Posner, about like how maybe we shouldn't worry as much about what they term one-sided terms in contracts and consumer contracts, because sellers would then use their discretion, to tease out the bad players, and but still, because of reputation, they would accommodate good faith requests. And I was worried, and then I also found evidence that like this discretion might not work as we hope as we were hoping that it would, and that like discretion is often exercised in discriminatory ways. It's true again that sellers don't have all the information ex ante, but it's more complicated than that. That's what I would just add. Um, Okay, I'm out of time. I'm happy
Yeah,
to stay if anyone has more questions, though.
thank you.
Yeah.
Thanks for the great talk. And yeah, if people want to stick around and ask more questions, please feel free. Otherwise, See you in 2 weeks from now.
Okay, thank you so much. It was great.
Anybody else want to come in? I mean, well, just
No
can I
one.
do a quick follow-up on that? So the flip side of that, though, is you could think about the discretion as a kind of risk that policyholders face. It's not the risk of disability, it's the risk that my disability claim is going to be denied. And I guess then the obvious question to ask is, well, who's the best party to bear that risk? Seems like I'd be happy to pay a little bit more in my policy if I thought, all right, I can get better review. And so then the question is, well, why don't insurers offer that? Like, we'll charge a little more, and what you get is the standard of review that you would want. And that means that, okay, everybody will pay a little bit more, and the people who get unlucky with a weird disability or a weird health problem where the insurer might otherwise turn it down, they've already paid. They've paid not to have that be an issue. I'm babbling, but does that make any sense?
No, it does make a lot of sense, and I was thinking about that. So you could think about like if sellers figure out that some consumers would actually value, right, better legal protections, more meaningful judicial oversight, then
Hmm?
they can offer the de novo review for a higher price, just like we get like flexible flight tickets for a higher price. But we're not seeing that. And then the question is why? And I'm trying to figure out why, and I have some potential explanations, I think, in the paper that are related to either informational or behavioral market failures. So the
Yeah.
idea is that, policyholders are likely underappreciating the benefits derived from a more meaningful judicial review. And if they're focused on driving down costs and less concerned about the future and about like unexpected or bad contingencies happening to them. People don't like to think about the chances that they would get sick or disabled and that they would get their claims denied. Then they might not be willing to pay that extra cost. Um,
Yeah.
and again, it's like maybe if we didn't have mandatory belts in our cars, seat belts in our cars, some would drive without belts. And then the question is again, when should regulators intervene? That's a difficult question to answer. I think it necessarily demands a careful cost benefit analysis, but I think that's the question that regulators should be asking, like what kind of judicial review we want in these cases. And if we don't want de novo, we don't want such a meaningful judicial review, we prefer differential review, which is less costly, then the question is, what other means do we have to ensure that insurers do not excessively deny claims? And we may think about like Dan talked about external reviews. We can think about external reviews. The problem with external review boards, from what I sensed from the interviews, at least with the plaintiffs' lawyers, is the revolving door situation, where the people on these boards are often also hired by insurance companies to give recommendations that conflict with like the treating physician's recommendations and so on. But other than that, if we have a way to ensure complete independence and no revolving door situation, then we can think about independent review boards. We can think about stronger regulatory oversight. We could think about heightened fiduciary duties, someone has mentioned before. There are many other solutions, but this is what I think we should think about.